Hi, everybody. Good afternoon or good evening if you're on the East Coast. Thank you for joining the National Immigration Law Center's webinar to talk about the latest updates on DACA and the DREAM Act. So my name is Shiming Chir and I work at NILC. It's been a whirlwind just from last night in terms of what's happening on a lot of different fronts. So we know you must have a lot of questions about the prospects for the DREAM Act passing by the 19th, as well as a lot of questions about what the ruling in the UC case last night means. So to help you answer those questions, we have a great set of panelists. We have Diana from the NILC DC office, who's going to give the update on what's happening in Congress and with the White House. We then have Josh from our DC office, who's going to talk about litigation around DACA. And as a special guest, we have Vivek, who's a managing attorney with the UC Immigrant Legal Services Center. He's going to talk a little bit more about the context for the UC lawsuit and also about what DACA recipients should be doing now. So we'll leave a lot of time at the end for Q&A. If you have questions, put them into the chat box, and we'll do our best to get to them during that time. And if you're wondering, we will record this webinar. So tomorrow you will get a copy of the slides as well as a link to the recording. So without any further ado, I will turn it over to Diana to talk about what's happening on the legislative front. Diana?
Awesome. So thanks, Shiming. I think, as we all know, since the termination of DACA back in September, immigrant youth and advocates have really been demanding action from Congress to pass the bipartisan DREAM Act, which would provide a pathway to citizenship for DACA recipients and immigrant youth who know no other country as home and are American in every way but paper. If you joined us for our last field call, or if you've been keeping up with the news around DACA, you likely remember that we as advocates were asking for the DREAM Act to pass before the end of last year. Of course, by now we know that that was not the case, and so I'm just going to briefly go over what exactly happened with DREAM in December. So essentially, we know that the DREAM Act, it has a large amount of bipartisan support, both in the House, Senate, and really all across the U.S. by voters, businesses, faith leaders, local electeds, and just tons of other diverse groups coming out and supporting a solution for these immigrant youth, right? But unfortunately, congressional leadership refused to really bring the DREAM Act for a vote until they worked out other priorities. And so as the end of the year approached and DACA recipients continued to lose their status, it really became clear that the way to pass the DREAM Act was to attach it to a year-end spending bill, which is known as a must-pass bill. And that just means that Congress has to pass this spending bill, in order for the government to continue being funded and continue running. And it's common practice to attach really important legislation that can get passed throughout the year to these budget bills. And so the first big date that was on the horizon was December 8th, where the first budget actually expired and Congress had to act in order to set new funding levels for the government. And then that obviously did not happen. And what instead happened was that Congress voted on a continuing resolution, a CR. And what that is that it really just extended current funding levels until the 22nd. And so that meant that they had until December 22nd, right before Christmas, to pass the budget that they need to set new funding levels and to fund the government, keep everything running smoothly. Unfortunately, they were not able to pass a budget, and they did yet another continuing resolution that extended it until January 19th. Our ask was that Congress work together to pass a spending package that addresses the most urgent needs of our nation, and that included the DREAM Act, because as we know, 122 Dreamers lose their protections every single day. To date, it's over 15,000, and Congress failed to do that. Many of our allies promised a solution before the end of the year, before they went home for Christmas, and that did not happen, which is why we are where we are today. Next slide, please. So where is the DREAM Act now? I think there's been many rumors about what is going on right now, about the different deals that are being made, what different members of Congress want, what the White House wants, and you may have heard that yesterday the White House televised a meeting with President Trump and a group of bipartisan members from both the House and Senate. And this meeting was a little bit confusing, but overall it was a bit of a nudge forward. It was confusing because to us, as even though to the public, I think it appeared to be a really great bipartisan gesture to move this issue forward. As advocates, I think we recognized that the group of people that were invited, the group of members of Congress that were invited, were not really the core group of people working very hard on this and to pass this forward. And so it was difficult to see how a solution could be reached in that way. And then at the end of the meeting, at the end of the day, the White House released a statement saying that after the camera stopped rolling, that there was an agreement of sorts reached that where both Republicans and Democrats and the White House agreed that whatever deal was to be had included a solution for DACA, the famous wall, what we're calling the family ban, and I will go into a little bit more, and they refer to as chain migration, and an end to the diversity visa program. However, we're calling this really more of a wish list because afterwards there were a number of members of Congress who actually came out and said that that was inaccurate. There was no agreement actually reached. And so I just want to briefly go over what these different pieces are, because I'm sure that you've probably heard of them, but are maybe unaware of what they mean. Of course, a solution for DACA, what we mean by that is a pathway to citizenship, and that we see that as the DREAM Act. Of course, President Trump would like to see a number of other things, including what he's referred to as chain migration, and we really see it as an attack on the family immigration system, which really just ends up keeping families separated, and attack on the diversity visa program, which is really designed to bring underrepresented groups, underrepresented countries a pathway to actually come to the U.S. who have no other pathway to come here. Really, this is just a wish list that is kind of holding the DREAM Act and a solution for DACA recipients hostage. And we are fighting very much against that, and doing our best to ensure that what is passed is a pathway for dreamers that really provides a pathway and protections that immigrant youth really need today. In addition to that, yesterday, very late at night, you may have seen that a court decision was issued, and I won't go into the details of that. I will let Josh go into that. But it was a positive decision, a great legal victory for what's happening with DACA. But I think it's really important to just note that that really doesn't in any way diminish the urgency for a permanent legislative solution. If anything, it really just heightens the urgency because as we saw afterward, the Department of Justice really made some statements that indicate that they would going to be challenging that, and that of course puts us in a place of a legal battle. And immigrant youth cannot wait any longer, and immigrant youth cannot wait for another temporary program. We need a permanent and legislative solution. And so right now, what we see as, again, the way to move this forward is a key date is January 19th, when that next budget, that next continuing resolution has to pass. And that's when that budget expires. And so Congress really needs to come together and make sure that in this budget deal, the DREAM Act is included, that protection for immigrant youth is included, and that we put an end to this fear and uncertainty that immigrant youth are living right now. Next slide, please. So the message to members of Congress right now really remains the same. The only thing that has changed is this new important date. Immigrant youth cannot wait any longer. There's 122 people losing status every single day, and we refuse to use immigrant youth as bargaining chips for this larger anti-immigrant agenda. We need the DREAM Act to pass by January 19th, and we need every single person on this call and your friends and everyone that you know to continue calling in members of Congress and tell them to pass the DREAM Act now. Again, even this legal victory really just heightens the urgency, and we still need a legislative solution, and we still need people to be active and to be calling their members and not letting them forget that we are keeping an eye on them and that we want to see them vote for a DREAM Act by January 19th.
Great. Thank you so much, Diana. And as a reminder, if people have questions, do type them into the chat box, and we'll get to them after our last speaker. So next we have Josh from our DC office, who is going to talk about some of the ongoing litigation to defend DACA. Josh?
Thanks, Shuming. So I'm going to introduce some of the cases that have been brought to defend DACA and talk about some of the latest developments and some upcoming developments in those cases. Obviously, a big focus for all of us is yesterday's order out of California, and so I'll spend a fair amount of time on that, walking through what it said and what it means, and then I think Vivek will talk about what that means in practical terms for folks who would be eligible to file a renewal application under that California order. So there's a couple of arguments that show up in most of the cases challenging DACA. The first argument is under a law called the Administrative Procedure Act, and it says that the decision in the Administrative Procedure Act requires a reasoned explanation that makes sense before a government agency can take any action, more or less. And so the first set of claims is all about whether the government in ending the DACA program followed the requirements of that statute, and we say they didn't. And then the second piece that shows up in many of these cases is pays attention to the statements that President Trump and Attorney General Sessions have made about immigrants, about Latinx people in general, about Mexicans and Mexican Americans, and ties those statements to the decision to end the DACA program to say that that kind of anti-Latino bias, anti-Mexican bias was part of the reason that the program was ended, and so it's unconstitutional for that reason. There's some other claims that different of the cases have. One claim that we're pursuing in our case, and I'll discuss this a bit later, is a claim really focused on some of the problems that happened around the October 5th deadline. There's another case that's really focused on some of the problems around the September 5th cutoff, and so I'll touch on those a little bit later. So on the next slide, let's start with the California case, or set of cases, which is really on everybody's mind today. The main name of the case is Region for the University of California versus Department of Homeland Security. Actually 5 different cases that were all consolidated together, brought by the University of California system and Janet Napolitano, a group of states listed here, the city of San Jose, 6 individual DACA recipients, the county of Santa Clara, and the union representing people who work for that county, which is an SEIU local. And so moving on to what happened yesterday in that California case, which is on the next slide. Yesterday, the court where that case was brought, which is the Northern District of California District Court in San Francisco, issued what's called a preliminary injunction. Preliminary injunction is a temporary order that lasts for the duration of a lawsuit that is intended to keep or restore things to the way they were before the lawsuit needed to be filed. So in this case, it's about restoring DACA to where it was before September 5th. And the court didn't entirely do that, but it moved in that direction. The reason it did that, what did the court hold? It held, first of all, that DACA is a legal program. We know a lot of the rhetoric around DACA has been that it's illegal, and the court said no. DACA has deferred action has a long history, and DACA falls within that history. And the second thing is that there's a substantial likelihood that determination that it was illegal under that Administrative Procedure Act for the government to terminate DACA the way that it did. And part of the reason that I think is really important to raise up is that DHS, in ending the program, didn't think about the effect of all of the people who rely on DACA recipients, their families, their communities, and their employers. And so in a lot of ways, the opinion raises up a lot of the messages that I know folks on the call and we at NILC have been making about why DACA is important, how much people rely on it, and the fact that it has been legal all along. So what did the court order the government to do? The court ordered that the government accept DACA applications from people who have previously had DACA, so renewal applications. It requires that the government provide notice of this new opportunity, this renewed opportunity to send renewal applications, and create a process for accepting and deciding those applications. But it does note that also the government is allowed to grant deferred action under DACA to new individuals on an ad hoc basis. We think they probably won't do that. They haven't had a lot of interest in resuscitating the DACA program so far, but the court recognizes that they could do that if they wanted to. On the next slide, there's a few things that that the court didn't order the government to do. Didn't order the government to provide advance parole, but like new applicants, it recognized that the government could consider advance parole for DACA holders within its discretion. And it said a few things about administrative discretion. It said that the government may take administrative steps, quote, to make sure fair discretion is exercised on an individual basis for each renewal application. It was always our understanding that that's how DACA was implemented, but we'll see what that means going forward. And the court also noted that the government may deport people, including DACA recipients, who it determines to be a risk to national security or public safety, or otherwise determines that they should be removed. And there's litigation around people who face removal for unfair reasons or without having their own process, and this case doesn't weigh in on those sorts of issues. But, and I think this is important, the court required that the government keep track of how it treats these DACA-related applications going forward, provide reports to the court, and we hope that that monitoring would address any concerns that the government tries to escape the spirit of this order using some of these, for example, administrative steps around discretion. And so this is all what's in the text of the order. On the next slide, I want to emphasize that despite this order from the court, the DREAM Act is just as urgent and important as ever for a lot of the reasons that Diana already said. Restoring DACA doesn't give the pathway to citizenship. This order is inherently temporary, and there is a risk that the order may not be permitted to go into effect because, as I note on the next slide, it is extremely likely that the government is, well, it's on a side in a little bit, but it's extremely likely that the government is going to appeal this order, and they're going to probably ask for courts to stop the order from going into effect. So we're not sure right now whether this order will be allowed to go into effect, or how USCIS is going to abide by it for as long as it is in effect, and that's going to affect some of the practical steps that folks that individuals will want to take. And again, that's something that Vivek is going to address in more detail. So that's a bit on the California cases. There's also the other main set of cases to watch are two cases in New York. One of those, Bataya Vidal versus Duke, is we at NILC represent, along with Make the Road New York, which is also a plaintiff, as well as 6 individual DACA recipients, Martin, Eliana, Antonio, Carolina, Mariano, and Carlos. Were joined side by side in New York with a group of states led by the state of New York. And again, in those cases, we're also challenging, in addition to the general issues around the end of DACA, we're also challenging the way that the October 5th deadline was implemented and the way that people were treated who had minor clerical errors. I think on the next slide, I show some of the next steps that we expect in these New York and California cases. As I mentioned before, in California, we're expecting an appeal. It could be as early as today. There might be a request to stop the order from going into effect at the district court, at the Ninth Circuit Court of Appeals, or even going up to the Supreme Court. And during the appeal, it's not clear that the order would be able to go into effect. In New York, we have a hearing next week on January 18th for a similar preliminary injunction, and a few things could happen if we're successful there. It could provide a second preliminary injunction, which kind of is a backstop to what's going on in California. And we're also asking the court in New York to go further and to provide relief for people who have not previously had DACA, so to new DACA applications, including from people who were too young to apply in September of last year. So finally, on the next page, I just wanted to raise up some of the other cases that have been brought challenging DACA around the country. A lot of these are in the DC, Maryland, Virginia area. There's CASA of Maryland on behalf of grassroots organizations, NAACP, which is raising up Black DACA recipient members of the NAACP, Princeton, Microsoft, and then also the Parks case in Virginia, which is particularly focused on people who were not able to apply because they were out of their DACA status on September 5th. And there's other people doing important legal work around other issues arising out of DACA. This is by no means the only legal work that's happening in this area, but we wanted to give a basic overview of some of the bigger cases where you can expect to hear new developments coming in the next months, with the big takeaway being that all of these this legal drama is can be important, and we're hoping that it offers some relief in the short term, but it's always a temporary solution, and the real permanent solution is going to come from a legislative solution, a DREAM Act that Congress, that it's more important than ever that Congress passed.
Great, thank you so much, Josh. So we're getting a lot of questions about next steps, what people who have DACA currently should be doing. So to help us answer that, we have Vivek, who works for the UC system, and they have a really model program that I hope other universities will adopt, which is having attorneys on staff to provide legal services to immigrant college students as well as their families. So Vivek, I'll turn it over to you.
Thanks, Xiuming. Thanks, Josh and Dinah, for providing that important legislative update and background on the litigation. I think there's a lot of important work being done out there. And so I'll turn to the question about what DACA folks should be doing now. I think there's a lot of questions after this court order last night. So I'll start with existing DACA recipients. And I just want to note that this is not legal advice, it's just information. Since we got a decision last night, a lot of things are changing. USCIS has not yet issued any guidance, and so if and when that happens, we'll be probably doing another webinar talking about what people should be doing. But as of right now, this is the information we have. So with regards to existing DACA recipients, the court ordered USCIS, as Josh mentioned, to accept DACA renewal applications but USCIS hasn't yet posted a procedure for renewal. So we don't know how that procedure will look like. We don't know if it's going to be exactly the same as it was prior to the rescission that happened on September 5th of 2017. And so right now we're advising folks generally to wait until USCIS issues a procedure to apply for DACA renewal via their website and other avenues. But I would say I think it's a good idea to start preparing your renewal materials if you do want to renew your DACA, and we're not able to before during the September 5th to October 5th window last year. And so that includes obtaining 2 passport-size photographs, making a copy of the front and back of your employment authorization document, and really looking at and writing down all your addresses that you've lived at since you last applied for DACA, and obtaining any documents that are related to your criminal or any immigration-related issues that you've experienced overall, even before your last DACA application. And this is really because in the new administration, any criminal issues or any immigration issues such as a prior deportation history, those could be factors that you'd want to consider about whether it's a good idea to apply. And so it's really important to talk to an immigration attorney or BI accredited representative prior to applying whenever USCIS issues a procedure. And if you do apply for DACA, let's say you submit an application today to USCIS, there's a risk that you lose your filing fee. Because again, we don't know how USCIS will implement the court's procedure. As Josh mentioned, there's also a chance that that the order will be appealed, and so that might change how USCIS issues any guidance. And so it's really important to know that if you do apply now with the prior existing I-821D form, I-765, and I-765WS, that you may risk losing the filing fee and not have your application processed. So on the next slide, I'll talk about those who have not applied for DACA. So as Josh mentioned, the court in Northern District of California, Judge Alsup, talked about those who are new applicants. And the court left the door open in some ways for new applicants who have never had DACA to apply for deferred action on an ad hoc basis. So again, we don't know what USCIS is going to do with this language, but just as reference, I put down the eligibility requirements for DACA as they existed prior to DACA's rescission. So these include being under the age of 31 as of June 15, 2012, came to the US. You came to the US before reaching your 16th birthday. You've continuously resided in the US since June 15, 2007 up to the present time. You're physically present in the US on June 15, 2012. And when you request deferred action or DACA, you had no lawful status on June 15, 2012. And you're currently in school, have graduated or obtained a certificate of completion from high school, have attained a general education development certificate, GED, or an honorably discharged veteran of the Coast Guard or Armed Forces of the US. And you have not been convicted of a felony, significant misdemeanor, or 3 or more other misdemeanors, and do not otherwise pose a threat to national security or public safety. Again, in this environment with the new administration, if you've been convicted of any crimes, I think it's really important to talk to an immigration attorney or a BI accredited representative prior to applying, whether, again, if you're applying for renewal or if you're thinking about applying for the first time to DACA. And if you are thinking of doing that as a new applicant, talk to an attorney. I think in the next couple of days, we'll get possibly more guidance on new applications. And like I said, the door is still open for new applicants. So we'll be seeing more guidance, hopefully in the next coming days. Next slide. I wanted to really talk about advanced parole and travel one of the biggest advantages to having DACA is that you can travel internationally on advanced parole, which would allow people to travel for humanitarian, business, or education-related reasons. At the University of California, seen a number of folks be able to take advantage of that and go abroad for conferences, for study abroad, and really gained a lot of experience that way. So what the court said was that the agency is not prevented from granting advanced parole in individual cases it finds deserving. So that's really important. That if you're thinking about applying for advanced parole and want to travel and think that there's an opening here, there is an opening. I do advise everyone who's interested in doing so to talk to an attorney or BIA accredited representative, because we don't know what it means for USCIS when they say individual cases it finds deserving. So we're still kind of waiting for that guidance. And so those are kind of the main points, main results of the court order as far as practical considerations as of this moment. I do know that USCIS has not posted anything on the website, although it has noted on 2 different USCIS pages that more information is forthcoming. And so we're still awaiting that information. So I'd like to turn it over back to Shuming.
All right, thank you, Vivek. We're getting a lot of questions in the chat box, so keep sending them in. The first one's for you, Diana. We've also seen, unfortunately, that temporary protected status, or TPS, has been ended for several countries, including El Salvador. So the question is, would the DREAM Act that you're talking about include TPS holders? Oh, I think actually Diana might. Oh, hello?
Hi, can you hear me?
Yeah, we can hear you now. Okay.
Oh, perfect. Yeah, so I don't want to give any misinformation, and I don't have the numbers off the top of my head, but it is my understanding that there are a few, there is a percentage of TPS recipients who would qualify under the DREAM Act. But again, I don't want to give any misinformation and throw out any numbers that are inaccurate. But I think, when the DREAM Act is really going to put us in a position where we can continue the fight for everyone to really earn a pathway to citizenship. And so I think that's kind of my answer for that right now.
Thanks, Diana. And also, we have a lot of other members of our legal team who are working on the Batalla case in the room with me, so they might also chime in to help answer some questions. So I think the big question from a lot of people is, when do we think DHS is likely to begin accepting renewal applications? Josh or Vivek or anybody sitting with me have any thoughts?
This is Vivek. I hope that it happens in the next few days, hopefully by the end of the week, I think. But I don't have any additional information on it, unless there are other folks that might be more connected to USCIS that do. I know they're aware of it. Like I said, USCIS did post on their 2 websites that information is forthcoming. But I really think it does hinge on how USCIS approaches the appeal and what happens with that.
The flip side of that question is there a deadline by which they're supposed to make an announcement?
I'll take that question, just to note that there wasn't a deadline specifically in the court's order and so we'll have to see if they delay to an unreasonable extent. We'll see what the California plaintiffs do, but we're also optimistic that to the extent that the order stands, the USCIS will put out guidance soon.
And back to Diana, we have a very direct question that gets right to the point. So what's the likelihood we'll actually get a clean DREAM Act, Diana?
The likelihood of a clean DREAM Act, I think that's the big $1 million question. I will say that we and other immigrant rights advocates are doing absolutely everything that we can to ensure that we get a pathway to citizenship and that doesn't harm the rest of our communities. That being said, I think we have to just be aware that we are our allies on the Hill are the minority, and that we may not get everything that we want and what we would ideally pass if you know, if we were the members of Congress. But we're going to continue to push back against all of these measures that I mentioned before, and do all that we can to ensure that this is not something that's going to harm our communities, particularly at the border, and the immigrant community at large.
Great. And Vivek or Josh, there's a couple of questions around Vivek's point that if people apply now before we get the guidance, they might lose their filing fee. Do you think that's likely, or do you think it'll be more likely that the application will just be rejected and the filing fee will be returned to that person?
That's a really good question. I think if people are applying, I think it's more likely that the application fee will be rejected, and the whole application will just come back to you saying that it's not following the procedures, or that USCIS has posted. So I think more likely than not, and this I've seen generally in immigration practice, if you file an application and it's incorrectly done, they'll just send back the entire application back to you, including the check.
All right, thanks. And there were some strong statements from the Justice Department last night about how they disagree with this decision. So Josh, can you talk a little bit about what the Justice Department might do to really stop this order and to continue to end the DACA program?
Sure. So the main next step that the Justice Department could take is to file for what's called a stay, and a stay stops a court order from going into effect. And so we've seen in the lawsuits challenging DACA that they've been willing to go to the appellate courts quite aggressively so far, and so they may do so again in this case, asking for a stay either from Judge Alsup in the district court, from the Court of Appeals, or maybe even from the Supreme Court. And if one of those courts grants the stay, then that would stop the preliminary injunction from going into effect, and USCIS wouldn't have to follow what Judge Alsup ordered. And that stay would again would last for as long as they were pursuing an appeal to the Ninth Circuit, or potentially to the Supreme Court, of all of the reasons that they disagree with Judge Alsup's decision.
Here's a question I'd like, because again, it's direct. So it's for you, Diana. It says, Trump's wish list is extortion. What are plans for outing this and fighting it? And if you remember, she talked about the wish list of ending the diversity visa, plus the border wall, plus changing family immigration as part of this package on DREAM.
Yeah, I think we really need to do our job as advocates and as you know, people who can see past what this is, to really start helping change that narrative. Like I mentioned, we're calling it the family ban. It's an attack on the unification of families, and ending the diversity program is really an attack on the diversity of our nation. And these are both things that make our nation great. Families are the basic structure and fabric of our society. Diversity, we know, makes us stronger, and so I think really just countering all of that narrative and calling it out for what it is, and that DREAM is being held hostage for these very anti-immigrant agenda. I think that's what we need to be doing, is just calling it out for what it is and making sure that the rest of the public is aware of what's really being done.
Thanks, Diana. And Josh, or maybe anybody from Team Bataya, there's a question about what if USCIS just refuses to follow the judge's order? We've already seen that USCIS has rejected renewal applications that were timely filed and properly filed. What if they just decide to ignore this order? What will happen then?
So I'm happy to take that, and maybe if there's other folks who are on the Vital team in the room with you shooting, maybe they can chime in as well. So this is why I think it's important that the preliminary injunction included the monitoring provision and the reporting provision, and those show that Judge Alsup is willing to make sure that the injunction is followed to the extent that it's allowed to go into effect, that it's followed both in letter and in spirit. So if a government agency doesn't follow an injunction, then plaintiffs in a case can go to the court and can point that out to the court. The court can then issue a follow-up order, and it's a similar for an idea of how this can play out in general. This is something that's shown up in other cases. It shows up generally that if an entity that's been enjoined doesn't follow the injunction, the court can order and can enforce against the entity as a whole and also the leadership of the entity. So that would be the next step if USCIS really tries to fight the order outside the court system. We think it's much more likely that they're going to try and fight the order within the court system, asking for a stay and filing an appeal.
All right, thank you. Also, there's a range of questions about who potentially is eligible to renew. Maybe you can take this one, Vivek. For instance, if somebody's DACA had already expired for over 6 months, could they be in the pool of people who could still renew? If their DACA is not going to be expired for, say, until, say, next year, 2019, would they be eligible to renew?
Yeah, those are good questions. So the way the court reinstated DACA was to reinstate it to the prior to September 5th, 2017, before the rescission, which means, and my interpretation of that is that they're reinstating the DACA program as it was before that date. And so all the standard rules would apply. So people who have an expired DACA right now, and it's been expired for more than a year, that they might have to apply with an initial application. Note that those are not new applicants for DACA. They're actually people who have previously had DACA, but it expired. For folks that it's been expired for within a year, I think they can just apply with the renewal. For folks whose DACA is expired in the future, depending on when it expires, I would say that would also be an option to renew now, so you can maybe get 1 more year or something like that to add to DACA before hopefully some kind of congressional action happens. So yeah, I think that there's all the standard kind of ways of renewing your DACA or applying for DACA are reinstated now with this court order.
All right, and we have a question about advanced parole because at one point I think one of you mentioned that USCIS is not required to process advanced parole, and we also said that advanced parole be considered on an ad hoc basis. So Josh or Vivek, can one of you elaborate a little bit more about what exactly the decision means for advanced parole and whether DACA recipients can travel abroad?
Yeah, I can take that. So the court stated that the agency is not prevented or is not barred from granting advanced parole in individual cases it finds deserving. So it's unclear what exactly that means. But as you mentioned, Shuming, it's true that the USCIS can choose not to pursue or not to process advanced parole applications. So I think we really have to see what guidance the USCIS is going to come out with regards to advanced parole.
All right, thank you. And let me see. Reading over the questions, a lot are just about specific scenarios. Let me see. Maybe this one should be easy for you to answer, Vivek. There's a question about what universities and colleges can do to make sure that immigrant students are being protected.
Yeah, I think there's a lot that universities and colleges can do. Here at the University of California, we have undocumented student centers, AB 540 centers that provide support to undocumented students in the form of financial having someone available to talk to about financial aid and other kind of issues that come up as a college student and as being undocumented. I think the other thing that has been really helpful, I know on campus, on all the campuses at UC, has been to have the legal services, and a number of other campuses are thinking through how to provide legal services to their undocumented students and following our model. And I think that's the other thing. I think the other, one thing UC did early on after the election was to issue some principles about non-cooperation, UC non-cooperation with ICE enforcement actions, which I think is a very important piece that gives a lot of solace to the students that are living on campus and just trying to go to school.
Yeah, NILC's been working on safe zones for K-12 schools and colleges, and I think Jess could describe that a little bit more.
Yeah, so to add on to what Vivek was describing, colleges can adopt resolutions that the entire college implements through its administration and trains faculty and staff about the policy. And the policies usually consist of several provisions, one of which is similar to what Vivek mentioned, non-cooperation with ICE officials, or at the very least requiring that if immigration officials of any kind come to campus, they have to present a valid warrant signed by a judge in order to either enter the campus or to arrest or detain a student. It can also include requiring that the school set up resource centers or a space on campus where students can go to get referrals for legal help or counseling or other guidance. And NILC has actually drafted some model policies that we have on our website if you're interested in checking those out and trying to encourage your college or university to adopt one if they haven't already. UC system does have one in place.
And a question for Josh, since yesterday's decision did not talk about the actual merits of the case, the other arguments you were raising or mentioned, what's the expected date of the next court decision on the actual merits of the UC case?
So in the order that was issued yesterday, it addressed the preliminary injunction and some questions of jurisdiction, so whether the court was allowed to hear the case at all. And it said that at some future point in time, it's going to address the government's motion to dismiss all of the other claims. But the court in that case didn't give a date for when it's going to issue that order. In the New York case, as I mentioned before, we have a hearing on January 18th to discuss similar motions to dismiss, as well as our motions for a preliminary injunction for our case in the New York plaintiff states case. And I should mention that also in the in the Maryland case, CASA of Maryland, that case also has a motion to dismiss that's been fully briefed. So you may see an order coming out of one of those cases next, but there's not a strict deadline on when an order is going to come out. They, for better or worse, courts don't give advance notice for when these things are going to happen.
And I think this question could be for any of you three. It's a question about how the injunction from the UC case affects the March deadline that was originally set by the president. Is it possible the president might extend DACA after the March deadline because of this decision? I don't know if Diana, you want to try to take that first? Or Josh or Vivek?
So
Hi,
I'd just say that, oh, go ahead, Diana.
Sorry, I think I was on mute. So I think it's important to reiterate that that March deadline was originally really a false deadline. When the program was terminated in September, it was in fact terminated, and no new applications could go in, no renewals could be sent in. And so the only thing that happens in March is that the number of people who speak in to lose their protections skyrockets from the 122 to well over 1,000 a day. And so that deadline is false because the program is not active as of now. It hasn't been active since it was given an end on October 5th.
Did you want to add something to that, Josh?
Nope, that is pretty much what I would say. And just to add that it makes it difficult to see what it would look like to extend the deadline aside from an action similar to what Judge Alsop's order requires.
All right. So the last question, I think this might be for you, Josh, or Vivek. How does the decision in the UC case affect DACA eligible youth who are currently in detention or who have deportation orders?
That's a good question. I think for folks that are in detention or otherwise eligible, I think that's something that would be definitely worth exploring with your deportation officer and your attorney, if you have one, to try to apply for DACA or apply for renewals. I mean, one note is that if you never applied for DACA and you are eligible otherwise, we don't know how USCIS is going to treat brand new applicants. And so if you do fall in that category, that's something definitely to talk to an immigration attorney about. If you are in detention and you have previously had DACA, then it's definitely worth indicating or talking with your DO and your attorney about how to leverage this new case to your advantage.
All right, thank you. I'm going to ask all of you in a minute to share one thing you want people to do right now, either to support the DREAM Act or one thing to do around DACA. I'll give you a second to think about that, and I'm just going to let people who are joining know that we have a lot of resources. Today we just created a document explaining the order in the UC case, and you see that as the first link. We have other documents talking about the different DREAM Acts that have been introduced last year, also the importance of making sure that we have what we call a clean DREAM Act that doesn't include other harmful provisions, and also a document around why we can't wait, because that's been a lot of what we've been hearing on Congress is they don't feel the urgency to make sure that the DREAM Act gets passed within a week or so. So I encourage you to look at those resources, especially the first one. And I'm going to ask our panelists to share like what's one action step that people can take right now. Diana, do you want to go first?
Sure. So I think it's really what I mentioned earlier is that remember that even this victory does not lessen the urgency, and like Shameen, like you just mentioned, there are still members of Congress out there who I think they're not feeling the urgency. They do still believe that there is a March deadline, or at least that's what they're saying. And so please continue calling your members of Congress, get your friends to call members of Congress, do actions, organize, and continue pushing until the end, and making sure that your members of Congress, your senators, that everyone knows that you expect them to get this done by January 19th.
And Josh, what do you want people to do?
So I was going to say something similar to Diana, but I'll just expand on it to say that folks should recognize that people's power continues to be important alongside whatever's happening in the courts over the next few weeks. And so to make your voice heard both in calls to Congress, but in conversations with friends and family, on social media, and in whatever way is available to you, to tell the story of why DACA is important, why it's important that a DREAM Act gets passed, and why the decision to end DACA last year was such a problem.
And Vivek, what do you suggest people do?
So I think this is what something I was referring to throughout my presentation, which is if you think you might be eligible for DACA, whether even if you've never applied in the past, I would advise you to try to talk to an immigration attorney or a BIA accredited representative to not only assess your eligibility for DACA, but also your eligibility for other types of immigration relief. As we all know, DACA is a temporary form of relief, and a lot of people may not know they could be eligible for other types of more permanent forms of relief. So that would be my message.
Great. So thank you to the three presenters, and also to those of you who joined. And again, you will get a copy of the PowerPoint as well as a link to the recording tomorrow. We'll send it to you in an email. And continue to follow NILC on Facebook and on Twitter. Join our email list if you're not already on it, so that as soon as USCIS issues guidance, which we hope they will do soon, you'll know that you can send in your renewal application. So thank you again, and we're going to sign off now.